Okay, hello. Hello, everybody. Hello. Welcome. Hello, just getting myself sorted out here. Just a moment. Okay, here we go. And there we go. Hello, everybody. Hello. Oh my gosh. Hello. Hi. Welcome in, everybody. I've got a unplanned but relatively short but important live tonight. Hello. Oh, thank you so much, McCracken. Yes, I was over on Hawk's Live, everybody. Hawk is over. He is live. I thought he and Falcon go do a live stream on the YouTube on Wednesday. It is Wednesday, isn't it? I hope I'm right. Just posted. Oh, you're so sweet. Yeah, see, great minds think alike, VC. That's what I'm saying. Yeah. There's a lot going on. There's a lot going on here. Okay, he does. Okay, excellent. So make sure you go over on the tube to hang out with them. They are I find it just a lot of fun. It's like hanging out with my big brothers. I really enjoy both Hawk and Falcon. And so I do. I'm so glad they're over on the tube of you. Here we go. So that's wonderful. Why can't the Supreme Court arrest those in contempt? Well, good point, and that'd be great. But there's like a lot of things that have to happen to go down the contempt road. Now, and we can talk about that. We're going to talk about that a little bit tonight. I've got a couple of updates here. This is the DVD case. And we've got to check out what's been going on because we've got some things. We have some updates from yesterday. Here we go, and they're short. They're quick updates. Yes, bonus. I'm not planning to stay for a very long time. Unfortunately, my voice is not great today. Sometimes if I do a longer live, it takes a little longer for my voice to come back so that it's not like listening to gravel. But we will do a little bit here. And oh, thanks so much, Breeze Mom. That's so sweet. Yeah, Garcia. This is our third case now, actually, everyone. Our third case where we have a contempt-like situation occurring. So let me just write down here. We have contempt, right? And the first one would be the JGG case. And this one's out of DC. And there was a probable cause finding. And then the next one is the Garcia case here. And that one's Maryland. Is Maryland MD? Is that right? MD for Maryland? Yes. Very efficient. I agree. Okay, MD. Oh, thank you so much, everybody. I tell you what, I have a lot of knowledge in my brain, and that means there are other things that have to be kicked out. And appropriate abbreviations for states that went. I think that went when I had to learn about the rule of perpetuities. So, or against the perpetuities. So they left. I have some holes in my knowledge. All right, and this one's Massachusetts. There we go. These are 3 cases now where we are really heavily going into the contempt zone. The JGG case, again, we do have a finding of probable cause. That case is continuing on, although it is under a different name now because JGG is now down in Texas. The Garcia case, of course, we're still hashing that out, and that's a mess. The math went. That's funny. Oh, yes, on my degrees in the dresser, of course. We all got to find inspiration wherever we can these days, right? So in Garcia, we're kind of halfway. We're almost there. We're getting real close. And then this case now that we're dealing with this DVD, and the judge has written a couple of things here that are pretty clear that we're kind of we're really in the red zone here. So let me say here. All right, I've got 2 filings from the judge today, and then we have a couple of electronic orders, all right? So the DVD case, everyone, is the one that I had gone through yesterday. This had just happened. This lawsuit involves a group of people who are saying, I don't think it's okay for the U.S. to send people to third countries. So there's the U.S., there's the home country, right? And then there's like a third country. And so the whole point of this lawsuit is to say non-citizens can't just be moved to a random third country, right? That's the whole point of the lawsuit, why it's been filed. So we have, thank you, VC. Yes. So we have a situation here where they just went ahead and sent some people over to South Sudan. Like that's the whole point of this case. Now, there's a preliminary injunction that's in place, and that means we have a court order saying you can't do that. And so now we've got a violation of a court order, which of course we know is a contemptible situation. All right. Okay. So we gotta watch out for that. Oh, Cynthia. Oh, I'm sorry. Oh, sending healing vibes to you. So here we go. Oh, the light flickered to give you some healing vibes. So let's go through the preliminary injunction filing he did today, and then I will go through the order that he set out as well. So there was, again, this kind of emergency hearing that was set for today where there were discussions about the preliminary injunction. So let me go ahead and just read through this quick. It's very short. Overview of the hearing and then the order that came out. So this is the memorandum on the preliminary injunction. Again, this was just a few hours ago. At today's hearing, the court found that defendants violated the preliminary injunction entered in this case by failing to provide 6 non-citizen class members a meaningful opportunity to assert claims for protection under the CAT. Again, I have to be careful about my words, especially today with some of the new things that have changed here over on the talk, before initiating removal to a third country. All right, so we have a finding of a violation of an order, all right? Any violation of an order, we call that contempt. So we already have a finding. The defendants maintain that ambiguity in the phrase meaningful opportunity, oh my gosh, these guys are such jerks, precipitated this controversy. So, oh my God. So they're saying, well, if you use the words meaningful opportunity a little different, if you twist it around and change the meanings, then, we're fine. We followed the court order. So it precipitated this controversy. Indeed, when the court issued the preliminary injunction, it declined to elaborate on what constitutes a meaningful opportunity, preferring instead to let experience show through hard cases the finer points of what's required under the due process clause. So this judge has actually already filed 2 orders explaining it. And he said, well, if you actually look at the law, you would know what that means. So I think he's pretty upset. To be clear, this is not one of those hard cases. Giving every credit to defendant's account, the non-citizens at issue had fewer than 24 hours notice and 0 business hours notice before being put on a plane and sent to a country as to which the U.S. Department of State issues the following warning, quote, do not travel to South Sudan due to crime, kidnapping, and conflict. That's a direct quote. As detailed on the record during today's hearing further facts regarding the availability of information, the hurried and confused notice that the individuals received, language barriers, and attorney access compound, and confirm this court's finding that no reasonable interpretation of the court's preliminary injunction could endorse yesterday's events. Nevertheless, given defendant's position that further detail would help defendants comply, the court offers the following summary and clarification of its preliminary injunction. All right, so so the court is going to just walk them through exactly what he means, which only occurs if you are pretty much an incompetent attorney. So here we go. Let's see what the judge says. All removals to third countries, i.e. removal to a country other than the country or countries designated during immigration proceedings as a country of removal on the non-citizen's order of removal, must be preceded by written notice to both the non-citizen and the non-citizen's counsel in a language the non-citizen can understand. Following notice, the individual must be given a meaningful opportunity and a minimum of 10 days to raise a fear-based claim for CAT. And this, again, is a legal element that's required by CAT, which is international law. So protection prior to removal. If the non-citizen demonstrates reasonable fear of removal to the third country, defendants must move to reopen the non-citizen's immigration proceedings. If the non-citizen is not found to have demonstrated a reasonable fear of removal to the third country, defendants must provide a meaningful opportunity and a minimum of 15 days for the non-citizen to seek reopening of their immigration proceedings. Right. This preliminary injunction applies to defendants, including the Department of Homeland Security, as well as their officers, agents, servants, employees, attorneys, any person acting in concert, and any person with notice of the preliminary injunction. So this is set out again, so anyone can be pulled in for contempt. Accordingly, no defendant may avoid their duty to follow the preliminary injunction by involving or ceding responsibility to any other person. Excuse me, everybody. My vocal cords are just real rough tonight. But this is a pretty major update, so the show must go on. And so then it is so ordered here by Judge Murphy. So I have not spent very much time in the CAT world, all right? The CAT world is this international United Nations treaty situation, right? So there are certain violations of basic human rights that, or, you know, what some people would call war crimes along those roads. And that is what's included in this. And so at this point, before we were tiptoeing through this area because of how the U.S. law, federal law was working and how they were trying to twist things around. So in Garcia, here, we were kind of tiptoeing around it. We're like, man, I'm not sure what's going on here. The JGG case was, again, just a mess because it was our very first one, but it's also a part of this one. Now in the DVD case, it's solid. So we are now in solid CAT territory, which means we are now in solid international law violation territory. All right. So before that, it was like, man, maybe, but now it's like, yes, that's where we're at now, and the court recognizes it. So here we go. That was the order explaining the preliminary injunction. So here's the order that came out then after the hearing today. Order on remedy for violation of preliminary injunction. Remedy is what everyone's asking for. So, you know, what happens? What's the enforcement? How does this work if they don't follow this court order? As set forth in today's hearing and at docket 118, which should be this one. Let's see, docket 118. Yep, so what we just read, 118, the court found the defendants violated the court's preliminary injunction. I'm trying to get it so the comments can be read here. All right. Having considered the arguments of counsel, the court orders the following remedy for defendants' violations. Now, again, we call this a remedy because we're in civil court. If we were in criminal court, this would be a punishment. Okay. So that's how we know, again, we're in civil court. For defendants' violations of the preliminary injunction, each of the 6 individuals must be given a reasonable fear interview, again, one of those elements, in private, with the opportunity for the individual to have counsel of their choosing present during the interview, either in person or remotely at the individual's choosing. Each individual must be afforded access to counsel that is commensurate with the access they would have received had these procedures occurred within the United States prior to their deportation, including remote access where in-person access would otherwise be available. Ooh, that's interesting. Okay, everybody, did we grab that? They're saying, we still need you to fulfill this element. Just because you're not in the country doesn't mean that this element's not to be fulfilled by the government. Each individual must also be afforded the name and telephone number of class counsel, as well as access to a phone, interpreter, and technology for the confidential transfer of documents that's commensurate with access they would have received were they in DHS custody within the United States borders. Wow, that's pretty major. So they're like, you all need to go to South Sudan and give these people their elements that are part of the preliminary injunction. And if you don't do that, this is kind of, if you remember back in the JGG case, right? We had we had 2 pieces. We had 2 hearings essentially, and then the judge issued an order saying the remedy is to take care of business here. But if you're not going to take care of business, then we're in contempt. This judge has skipped past all of that. We're already like 3 steps beyond where JGG was, just in these 2 sentences. The judge is saying you have to do this in order to clean up your violation of my order. So if you do A and you do B, we're on the path to you basically cleaning up or making your violations okay again. So we got to get back to the 0. Next, each individual, along with the class counsel, must be given no fewer than 72 hours notice of a scheduled time for each reasonable fear interview. All right, here's element 3. He's being extremely specific. Should any individual raise a fear with respect to deportation to the third country, the DHS determines falls short of a reasonable fear, the individual must be provided meaningful opportunity in a minimum 15 days to seek to move to reopen immigration proceedings to challenge the potential third country removal. So now this is element D, and all of this apparently is going to be taking place outside of the U.S. During that 15-day period, the individual must remain within the custody or control of DHS and must be afforded access to counsel that's commensurate with the access they would have been afforded if they were seeking to move to reopen within the United States borders. All right, so that's another element here too. Should any individuals, defendants must provide status reports every 7 days as to all 6 individuals. Should, this is F over here, should any individual move to reopen, the parties must also immediately provide a status report and continue providing status reports every 7 days thereafter on the status of the motion to reopen. Wow, that's a lot. That's a lot of stuff here. And again, the judge is ordering this to cure the harm that was done when they violated the judge's order. Now, if you don't cure, then you are in, big trouble, because that's a full-blown contempt situation. DHS, in its discretion, may elect to provide this process to the 6 individuals, either within the United States, should it choose to return them to the United States. Oh my gosh, that's amazing. Oh my gosh, that's amazing, Judge. Oh my goodness. All right, or abroad, if at all relevant times, DHS retains custody and control over the individuals, and conditions can measure it to those the individuals would be housed in were they still in DHS's custody within the United States. Oh my gosh, this is genius. Okay, everybody. So the judge set out actually multiple steps and said, back the truck up. You need to give them every single piece of what they're entitled to. Now, what they're entitled to may be hard to do if they're not in the country. And so the judge is like, we can go ahead and bring them back and then cure your contempt. cure your violation of that. Oh, I love that. I love how this language is in here. So he's saying you can do whatever you want, government's choice. Leave them in South Sudan, but you still need to provide all of these elements, or bring them back, and then you can provide all of these elements. So we love that. We love that. Exactly. It'd be a heck of a lot easier. This order reflects a remedy in light of the court's finding of a violation of its preliminary injunction that has been narrowly tailored in accordance with principles of equity. The court cautions defendants that this remedy should not be construed as setting forth a course of conduct that would constitute compliance with the preliminary injunction, and the court is not, in ordering this remedy, making a finding or conclusion that compliance with these processes before deportation would have satisfied the requirements of its preliminary injunction in the first instance. So the judge is saying all bets are off. This does not mean that you're going to be fully okay then, or off the hook for this. You're still in the doghouse. I'm not ruling on the actual issues here regarding that contemptible situation. This is just the basics to even get it so that you're like not on fire. This is triage, is what the judge is saying. Christy Nome says they're not coming back. Well, and she also says that the president is in charge of habeas corpus. So it's hard to know. Her truth bombs don't hit quite right, I would have to say. Exactly, VC. This is it. You need to do it. Or, this is it. And this Yakov fella, this fella right here, let me make sure I have his name correct. We don't want to mess up anybody's name. That would be awful, right? Let me make sure I get his name here. Where is it? Okay, here we go. This Yakov guy right here is this one. It's like, you're going to be going to jail, dude. You're going to be going to jail. Because you had the order, you knew the preliminary injunction, you knew the full story, you stood up in front of that court saying that you were going to comply, and you didn't. And just by even stepping in and filing this argument that they had against this emergency motion, this guy should lose his law license. This is so far out of the realm of what's appropriate for behavior. Now, Yakov's in charge, but then his underlings are these two down here. Senior Litigation Counsel, he knows better. Mr. Seaman, he knows better. Mr. Seaman, you know better. You did bad things, and you know better. And then Elianis Perez, you know better also. So each of these three attorneys need to be on the list. And then we've got this Mary LaRockers here out of Texas, which tracks. Right. Yeah. Roth is really a piece of interesting work, isn't he? So, she didn't understand it. Yeah. Habeas. Right. For Senator, can they hold Noam accountable? So this one, not only do we have a Noam situation, but then we have that other, so this is this is the dog lady, right? And then the other one, what's her name? Oh, I keep forgetting her name. And I think it's because I don't like her. I think that's why I keep forgetting her name. Let me see here. Let me find her name. Where's her name? Here we go. Bondi, the AG, the Bondi lady. She's also responsible, right? So anything that's going through the Department of Justice right here, because we've got an assistant to the Attorney General, she's also responsible. So Bondi here. So this is that. Yep. So Noam, the dog lady, and then Bondi. I need something to associate with her name so that I can remember her name, everybody. I've got to do that because I am just really forget everybody's name. I mispronounce, but what do we have here to tie to Bondi? Legal Barbie. I don't know. I like Legal Barbie though. Blondie. I don't know. I like Blondie. Ice Barbie. I don't know. I'm not sure about that. Prison Glam. No. But that's Noam. Ava Bronte, Ted Bundy. Oh my goodness gracious. She's not slick like James Bond. Oh my goodness. Bail bond. Bail bond. I don't know. I mean, bail bond's like, that doesn't have a negative connotation for me. I know, everybody, I'm a weirdo. Tanya Harding. Oh my goodness. Oh my gosh. Okay. Legal witch. Well, I've met some legal witches and they're lovely. The ones I've met. Oh my gosh. Fonzie. Bad Faith Bondi. All right. Let's call that. I like that one. Bad Faith. The Bad Faith Bondi. All right. So the dog lady and Bad Faith Bondi are both part of this Marlon Brando. Oh my goodness gracious. Oh my God. Yes. She keeps pulling back in, right? She tries to get out and they pull her back in. Oh my goodness. 8647. All right, everybody. I can't see through the tears. All right, so, these two people here, and then, of course, we've got, and I know it's a cheap shot, but I'm going to take that cheap shot of Marco Polo, also as the Secretary of State. So those three, and then it's possible that others could be involved as well. So, and here it is, the Department of State here. So the thing is, again, everyone, and I would remind you that the pilots, the crew, the people who worked to make this happen have all been, a part of this. They're all like co-conspirators because they were helping to effectuate the violation of a court order. So I think that's so important to remember that. So again, as I've been doing, to the pilots and the flight crew out there, yeah, I'd charge you. I charge you right now. If this is my case, I'd charge each and every one of you. And that's what I'd do. And I'd hold you without bail because you could fly away. But that's just me. That's my moment of being serious. Yeah, absolutely. Could do the law license, yes. But that whole process takes quite a long time. So, but something that we shouldn't ever forget about. So here's the docket, everyone, for the DVD case. Keep your eyes on it. Again, this is huge. The judge has already said, you violated my order. We're done. So we've already gotten further than JGG in this situation. And we're going for, again, we're still waiting exactly on, it's like the sword's hanging here, but we don't have that final push on Garcia. And then DVD, though, he's like, we're not playing. You're done. You've already violated the order. And you need to do A, B, C, D, E, F, G to each one of the 6 people, wherever in the world they are. And if you don't, you're going to be in violation of the second order here. And if it's easier to do A through G in the U.S., well, bring them back. I'm not saying you have to bring them back. And that's the other part that I love. The judge isn't being like, oh, you got to bring them home immediately. Oh, no, bring them home. No, he's like, no, you just got to give them the legal rights that they were allowed to have under my preliminary injunction. He's like, you still got to just give it to them. You want to give it to them over there? Fine, whatever. But there's still 6 pieces that you owe them. And so you need to give them those 6 pieces. I don't really care how. And, I'm loving that. I'm absolutely loving that. Oh my goodness. All right. So one last thing here, just to remind everybody also on where this is headed. We've got electronic order regarding the preliminary injunction compliance. So defendants must submit by 5 p.m. on May 28th under the pains and penalty of perjury. That's extra. We don't hear that all the time. Under the pains and penalties of, and then we're not talking about contempt. We're talking about perjury. All right. Perjury is 5 years max in prison. So, oh my gosh, everybody. Oh my gosh. All right. A declaration from an attorney of record in this case that certifies One, that notice of the clarified preliminary injunction has been provided to all persons involved in the removal process. So each person needs to have notice now of the injunction. And number two, that all, here we go, that all individuals potentially involved in any removal that may implicate this order have been told that failure to comply with the terms of the preliminary injunction may subject them to civil or criminal contempt. Okay, so that's pretty powerful. So number one, all 6 people need to have all of those elements and understand that their lawsuit's been updated. And number two, any individual who would even potentially be involved, now I'm talking to you pilots, I'm talking to you out there, in any removal that may implicate this order, have been told that failure to comply with the terms of the preliminary injunction may put them in civil or criminal contempt. So this doesn't say military or, people working for the executive branch. This says individuals, right? All right. So if you're on a plane and you are there just to make sure that there's enough parachutes for everybody, and so you're just hanging out on the plane, that's you. You're included too. All right. Parachute person, you're also included. And again, going backwards to the pains and penalties of perjury, that means if any of the information is false, we could be looking at perjury charges, which again, incredibly easy to prove perjury, incredibly easy to prove it, and a 5-year prison. So this, I think, is the harshest order I've seen yet. Yeah. Now, I don't know. I mean, that's the other thing. I don't know if it's flight attendants or who it is, the flight crew, because there's people. I don't know how planes work. Where's legal dad when you need him? So there's planes, but there's military versus commercial planes, and then there's people from other countries that are like, well, we didn't know what was going on. So there's just a lot of people involved. But this doesn't happen just because, the 3 stooges here decide to come in and order people around. This has to have a group of people working together in order to make this occur. And they didn't even make it occur that well. I mean, it was pretty sloppy. Because originally it was supposed to be South Africa. And then 30 minutes later, they're like, man, we'll do South Sudan instead. Or maybe they always meant Sudan, but just accidentally said South Africa because, they're incompetent. All right? If that makes sense at all. As I'm flipping through here. Right. So we've got Bad Faith Bondi, the dog lady, and then Marco Polo. Do we know where the rest of the group is? And does this apply to them? So anybody included in the class in this case is who this applies to. All right. So let me pull this. Here. This is a full class. So although these people are the ones being named, right? There is a class certification in this case saying anyone who is similarly situated that has been included as part of the class are protected. That means that preliminary injunction covers you if you're part of the class. And let me show you the line here that I think is the most important thing here. So, all right. Defendants violated the court's preliminary injunction. Having considered the arguments, orders the following remedy. Each of the 6 individuals must be given a reasonable fear interview in private, right? And then let's see. So these specifically have those elements A through G. And then we come over here. Okay. Let's go to the preliminary injunction. Sorry, wrong one. Here we go. All right, so non-citizen class members. So we've got 6 non-citizen class members. So again, class means a group of people that's already been designated as part of a class. The preliminary injunction covers them. That's what this is all about. So it's these 6 people are just like all the others. It's just unfortunately they were the ones picked up and put on planes. All right, does that make sense to everybody? So, defendants violated the injunction entered by failing to provide 6 non-citizen class members meaningful opportunity to assert claims for protection. Meaning, I don't know how many people are in the class. Let's just say there's 50 people in the class. All right, 6 of those 50 were moved to another country. If another 10 of those people are moved to another country like this, we're in violation again. If the rest of them are, then we're in violation again. So we're only dealing with the ones who have been moved at the moment to remedy it. But this injunction covers everybody in the class. Every single person in the class is included. Yes, exactly. And that's the other thing too, where the judge is like, you need, upon penalty of perjury, to provide this information to these 6 people, and you need to have counsel involved as well. All right, so that's really important to know that. Museum. Oh my goodness, that would be very interesting. Oh my gosh, what if those countries lose track of them? So that's a great question. And that's another thing too that the judge is talking about regarding this jurisdiction here. Like, you need to keep jurisdiction of these people or you're going to be in violation of my order. Now, if for some reason the country is like 6 people, what 6 people are you talking about? That's pretty bold because that would be, oh my gosh. So if the US government sent 6 people over to another country, I don't know what the agreement is, right? I don't know what the agreement is, but if jurisdiction switched, there had to have been an agreement. And in that agreement, it would have said, this country is taking the custody of these 6 people, right? And so if they take the custody of 6 people, but then lose those people, then they've broken the contract, right? It's difficult because we don't know what's in the contract. We don't know what's agreed on. We don't know if this was just Marco Polo hanging out, having a few Cosmos and writing something down on a napkin. We don't know. And with the level of professionalism that's lacking in this administration, it's very difficult to know. It's very difficult to know. So I would say that's a huge issue. The remedy is, and again, I adore this judge. The remedy is, look, we're not saying you can't do this. What we're saying is there are 6 pieces that are supposed to have occurred here. Sorry, 7. Sometimes I forget the first letter. There are 7 pieces required to my preliminary injunction. You didn't get those 7 pieces to each of these 6 people. So you need to go give them the 7 pieces. Give them their 7 pieces, and then whatever happens afterwards, we'll take it from that moment forward. So give them those 7 pieces. I don't care where they're at, and then report back about that information. And I want to make sure an attorney of record has proper information that everyone has received their 7 pieces here. All right. And I'll try to make one. Yes. Oh, absolutely. You got to do that. You absolutely have to do that. They have to have those first. Yes. So, and the judge isn't saying like, you can't do what you did. What the judge is saying is you violated my order because you withheld these 7 pieces from these people. These people are supposed to have 7 pieces. I ordered them to have A, B, C, D, E, F, G. I ordered that, and you didn't give that to them. So now you need to go to where they are and give it to them. That's the remedy. And, if you want to bring them back to the US and give it to them here, if it's easier, great. But I don't care. The point is, I ordered 7 pieces and those people will get those 7 pieces. That's what they're saying. Oh, thank you so much, Rochelle. Oh, thank you so much. Yeah, this gets really kind of tangled up. The language can absolutely get really tangled up here. They aren't technically supposed to be removed until these 7 pieces. Correct. But that is the remedy for the violation of the preliminary injunction. But then in the final paragraph, the judge is saying this reflects a remedy in light of the court's finding of the violation here that's been narrowly tailored in accordance with the principles of equity. The court cautions defendants this remedy should not be construed as setting forth a course of conduct that would constitute compliance. So the judge is saying you need to give them these 7 pieces immediately. And after those 7 pieces, I'm not going to say that you're in full compliance. What I am going to say is in this moment, in this situation, this is the bare minimum in order for you to put the fire out to stop the bleeding. Can the violation of a preliminary injunction be appealed? So that's a good question. And it's kind of a weird, we're in a weird gray area because, our preliminary injunctions are this huge question from the U.S. Supreme Court right now, right? On whether or not it's a final it's a final act that can be appealed and then asked a question about. But when we're talking about a violation, I don't know what court would have more jurisdiction than the court that issued the preliminary injunction to make the determination that the preliminary injunction's been violated. You know what I mean? So let me put it to you like this here. All right, so the district court set out the preliminary injunction and set out the 7 factors. All right, we'll just call them the 7 factors here. So the district court is saying you violated the 7 factors. Now, if you appeal it to the Court of Appeals, all right, and you go in and you say, we did not violate the 7 factors, what's that Court of Appeals going to say? Like the judge wrote the factors. So the judge is the one that determines whether or not the factors have been violated. I mean, the Court of Appeals judges, they're like, we don't know what he was talking about. We don't know what the intent was. This is that preliminary injunction. Whether or not a preliminary injunction is constitutional or not, that's being appealed left, right, center, and whether or not there's authority to even have the preliminary injunction. But that's a different question. Whether or not the preliminary injunction's been violated, that is going to be in the realm of the judge that makes the preliminary injunction. Oh, there's penalties. There's penalties coming right now. Everything's up in the air. This is that moment when you hold your breath before the roller coaster goes down. This is that moment because the judge has said here, you have until the 28th to give us information that is certified, basically, that is authenticated, that you have told each and every single person that was removed that this order has come through, all right? And every single person who could be involved in the whole process, that this is going to be a violation of the injunction if they, do this. So that's what the judge is saying. So we're holding our breath until May 28th. In order to give them time. And this, again, the amount of time that's allowed, this is really a quick turnaround. You might say, well, that's a whole week, and it will seem like forever. But legally, this is like a blink of an eye for a court order in here, right? So we're on a Wednesday, and they're saying, look, you have to get to the country, talk to the people with the certified attorney of record, fly over there, make all of the accommodations that you need to, and then pull each of the people and talk to them. We don't even know where the people are. And, there's like a civil WAR going on over there. So he's like, look, I'm going to give you 7 days to get all of your stuff sorted out and then get it filed, right? So, yeah, and then get it filed. Yeah, holiday. Good thing there's the internet. I mean, can you imagine? I can't even imagine. So if people are going over there and they're talking with other people and they can get this whole declaration, all of this stuff written out and then send it into the court from, wherever they're at. But if that wasn't an option, like they'd literally have to fly back or like overnight it somehow to get it to court on time. So you know what? Thank you, internet. Thank you, Internet. Maybe I should all act in good faith. It's a lot. It's a lot. It's this good faith element seems to they're really struggling with that. What kind of penalties? Disbarment. So that I don't know. Disbarment really takes a lot. Like you got to really screw some stuff up for disbarment. And the amount of, problems here, I'm not sure would rise to the level of disbarment, but we have a different kind of system. You can have an admonishment. You can have your license revoked for a period of time. You can have a public square humiliation. I forget what that's called. Or you could also be forbidden to practice law in particular courts. They could just say you're not allowed to practice in federal court. There's all different kinds of things that can happen. Exactly right, CM. Exactly. The court can't disbar an attorney as a penalty. Exactly right. You have to go through the ethics process. There has to be a full investigation going on, and then like a little mini trial that goes on. And then after that, there's a verdict. And then after that verdict comes out, then they try to figure out what the best, most appropriate punishment is. So this isn't something where a judge is like, I'll be taking that bar card now. That's we're on a different road. We're in a different room. Yeah. Yank the license, let them sit and think about. Well, right, and again, it just doesn't. Unfortunately, unlike any other kind of regulatory license that can just be pulled if you violate stuff. Your law license, it goes through a full procedure. There's like 25 steps involved, and it can take a couple of years. I think John Eastman just last summer, or maybe the summer before. All the years are merging together. Everybody, maybe it was 2024. It must have been, or was it 2023? Was it 2024? I think it was 2024. Anyway, he lost his law license. I think it was this past summer. Anyway, I digress. But it was years after the situation he was involved in had occurred. Years. And he fought every single step of the way. And his license was finally pulled. Was it last year? Thanks, Nicole. I appreciate that. Yeah, it seems like they all blend together. Attorneys get due process during disciplinary hearings. I know. Yeah, right? I mean, isn't that ironic? Like you can have it, but was it 2024? Okay, I appreciate that. Yeah, I think so. Can they keep them behind bars while that's going on? So the question is, we don't know where they are, right? Because when we were dealing with the Salvador situation, they did this like press tour with the, prison gnome walking around in her cosplay. So we were like, whoa, we can see what's going on there. We don't know. We don't know where these people are. We don't know if they're together. We don't know if they're at different places. This country is really going through a lot right now. And I think in the earlier filing, they're saying they have millions displaced in their own country because of the fighting and the bad things going on over there. So we don't even know where these people are. So that information's not been made clear at all. Prism Gnome. Eastman disbarred March 2020 plus 10,000. Right. So his DC disbarment hearing has just happened. That wasn't that long ago, but it was for actions that he had done. Yeah. So after the election in 2020, the problems were what was done after that. So that's a big piece of it. But the actual pulling, the hearing itself, and actually I think they've got part of that recorded. I don't know. Did we watch that on the tube once, everybody? I feel like we pulled up his hearing once. You got to be careful though, because there's some questionable other things going on in that situation. Yes. Take a page out of, right. No empathy. Yeah, there's a lot of, I mean, come on. Are you freaking kidding me? I mean, they're like, well, you didn't say the word, what do you say? Meaningful opportunity wasn't defined well enough. Are you freaking kidding me? That's like, you could get kicked out of law school for asking that question in class. Well, technically you probably couldn't, but they won't look at you the same if you ask that. Well, what do you mean by meaningful opportunity, professor? Like, you're done. You're over. Your reputation is done at that point. Oh my gosh, because it's just out of control. It's ridiculous how these attorneys are twisting things around. And they're like, well, that's what you do if you're an attorney. No, you act in good faith is what you do. You look at the law, you look at the facts, you look at the evidence, you look at your arguments, and you have a good, clean fight, and the winner, wins. You don't play around in bad faith and throw sand in somebody's eyes and kick them in the no-no zone. You know what I'm saying? That's not good faith. That's not a good fight. That's nasty. That's a nasty fight. Yeah. Again, and it's the same thing that we had with the U.S. Supreme Court, right? Facilitate. What does facilitate mean? What are you talking about? You twist when you know you're wrong. Absolutely right, John. Absolutely right. Absolutely right. Oh, territory. Exactly. They do that with a ton of words, like, within the territory of the United States. Like, are you freaking kidding me? Come on. Sorry, Bay Grandma. Sorry. You know what I'm saying, right? I mean, there's certain zones that are like, bad for. What am I trying to say? You know what I'm saying, right? No, don't waste a Diet Coke. It's like $10. A Diet Coke is expensive. Oh my gosh. Oh my gosh. I have to educate. Yes. I'm okay. It doesn't take much out of me. I just hope I can be descriptive enough. Like certain things go wrong. Like I don't remember the state abbreviations, but yeah, no problem. I know, John, what are we doing? What are we doing here? I know what you're saying. Thanks, Big Grandma. I appreciate it. Oh my gosh. Yeah. So again, everyone, I think the end results or the rubber on the road, is that what the Legal AF fella says? Oh my gosh, I love that so much. Is it Michael Popak? Oh my gosh, he's just the best ever. When he explains stuff, it's like you're just the greatest. And I fall over laughing almost every time. But as he says, where the rubber meets the road is that this court's like, you know what? Let's do this. We're coming out hot here. We're not even gonna play around. I'm not doing 50,000 hearings. We're in and we're done. So I love that. Granted some hope. Oh, absolutely, Amber. Absolutely. There's hope. There's still hope. Because justice matters. It certainly does. He's great too. Gosh, I forgot his name. Glenn? Is it Glenn? Glenn something. Oh my gosh, everybody. I apologize. I'm terrible with that. Conscience would be, it certainly would be. Certainly. Yeah, he's with Midas Touch, but I think he's got his own like Legal AF podcast. They just do such great work over there. Some of the people, I just am like, what? But I don't care. It's still good information, good, clean information over there. And I appreciate that. Yes, Glenn, thank you so much. Yes. Yeah, I think it was was he a federal attorney? I think he still is, probably. He's got great information. I love how he breaks it down too. He doesn't have that twist that Popak has. I'm telling you, I'll fall off my chair sometimes with the Popak. Like, what did he just say? I love it. They do good work. And again, for myself, I started looking into what was going on by not going to the media because I felt like the media didn't know what they're talking about. They're mixing up what the words meant. They're mixing up what the orders were. They were just not attorneys. And, I don't expect all journalists to be attorneys, but I think if you're going to report on an order or a court proceeding, like you should have some background in that. So I got tired of it. And so that's why I started pulling the source documents myself and looking through them. And, I'm glad that we have so much available to us. There's no reason why you can't see the literal document itself. And, all the pieces of it. We even have evidence, like we can see the actual emails. We have this available. So there's no question here, like, oh, well, what are the facts? Like, I'm holding the facts in my hand right now. Here's a handful of facts right here for you. And that, I think, really just kind of cuts through the noise of not really knowing who you can depend on for that information. Right. Yes, yes, help us. Oh my gosh. But I don't want to go to Alderan. I want to get some power converters. Oh my gosh. That's the fact. That's the fact, exactly. They're like, that's not the fact. I'm like, well, but if this isn't the fact, what am I holding in my hands? If this isn't an opinion. This is a sheet of paper. This is a fact right here. Oh my goodness gracious. Hello, Navy vet. So I was updating everyone. I'll do a closing statement here. Closing briefings. So we had an update on the DVD case. This is the case involving 6 people who have been removed from the country without complying with the court's preliminary injunction. All right. So the judge has said, you did not comply with my injunction. And so because of that, you need to remedy that. You need to cure your mistake. And in order to cure your mistake, there's 7 factors. You need to go over to each of those 6 people and give them these 7 factors and report back to me within a week by an attorney of record here confirming that these 6 people now understand the case has been changed and that everybody knows that you're going to have a violation of a court order if you do this again. So the judge made that pretty clear, gave them a week to get all the information put together, told them exactly what information they need to get from the people. And, we're going to need to wait now. Deadlines, hard deadlines help. Well, I think there's a couple of or else pieces here that I can really appreciate. First, under the pains and penalties of perjury, that's pretty significant. If you are, the other thing too, and most people probably don't get the gravity of this, because he's saying here, a declaration from an attorney of record in this case. And then he's saying, though, under the pains and penalties of perjury. So this judge right here is saying, I do not trust that the attorneys are going to do the right thing necessarily. That's why this warning is here. So if you're an attorney and he's like, you need to file something, and I need to remind you that it would be under pains and penalties of perjury if it's incorrect. So this is actually pretty huge right here. This is a pretty big moment where a judge is reminding attorneys of the perjury repercussions. Heads up. Right, exactly. Like this judge is like, we're done. We're done. And again, we have 3 cases where we've got contempt issues going on here. The JGG case, the Garcia case, and then now the DVD case. And I would say this is the one right now that we're talking about is the absolute fastest and strongest, most significant, I don't know, threat's not the right word, but encouragement of compliance that we've seen yet. Yep. Perjury can be up to 5 years in prison. Right. And when a judge says this also, that's kind of like the secret symbol or the secret signal that the judge is willing to go forward on perjury charges. So sometimes you just kind of are like, hey, perjury, right? Wink, wink. But if a judge is saying that, the judge is like, and I'm not playing around. Like if I find out you've lied, we're going to be in a perjury situation. It's the judge's bat signal. Yes. When will Yakov and the others be arrested? We know they won't comply. Great question. Who knows? We're in kind of this weird situation where it's like, man, I mean, we need like a police squad just to go after attorneys. That's one thing too, as a quick side note that I've noticed. I think it's the guy from Democracy Docket? That team over there, by the way, in Democracy Docket, I think that's what it's called. Amazing. And he was talking about how there are attorneys now that have been pushed out of the DOJ and various other situations because of ethics, because they have some. And they're like forming firms in order to represent people being targeted by the administration. And I tell you what, is it Mark? Oh, we love that. I tell you what, that story is so inspirational. It is so incredibly inspirational. Now, I'm very far removed from Washington, D.C. I'm not over there. I don't understand what goes on over there. All the states are all tiny and the jurisdictions are weird. But I do understand when you need to leave a job because they're asking you to violate your ethics. And then to come back and to fight against the bad guys, I think that's just freaking amazing. Yeah. That's a constitutional crisis. Yep. Any case targeting their right. Exactly. Instantly fired. Right. Not about telling the truth. Exactly. And so that's why that little perjury nudge is there. I remember I asked, oh my gosh, we were in a hearing. This isn't good practice. Don't do this if you're attorneys, people. But I was a very young attorney, and I was questioning a mother in a situation, and I knew what she had done, but she was dancing around it on the stand. And so I was like, well, and what about this? And she's nope. And so I kept asking the questions, and I was just leading her around, and she wouldn't give me the gold nugget I needed for the judge. And so finally I said, you do know what perjury is, right? It's like, you can't ask them that. I mean, that's pretty prejudicial. There was no jury, but on the other hand, that's that moment where you're like, I know you're lying. And now you know that you're lying. The auto pen. Yeah, I've got a lot. These two, everybody, are my new ones. I just got, very exciting. How many seasons this story will last? Oh my gosh, I know, right? Of course, it's all about the wording. That's what the law is. It's all about the words. And the words are, our weapons. But if they think they're special, they're not. All attorneys are trained in words. So they're like, oh, we don't know what meaningful opportunity is. Do you think all of the, I don't know how many attorneys are in the U.S. Let's just say there's like 500,000 attorneys. That's a lot, but we'll just estimate. You think 500,000 attorneys don't know that you can dink around with meaningful opportunity, waste the court's time until you get to the end of the road where it means what everybody knows it means, right? Of course we do. But we choose not to do that because that's bad faith. Like, we choose to fight a good, clean fight, and whoever wins, wins. Right? We're not kind of going down the slimy road here of saying like, oh, what do you mean by you? Do you mean you, or do you mean like you? Right? So, I mean, that's the thing. Right. Exactly. Jake Tapper. I'm staying away from Jake Tapper right now. I can't handle any more negativity. I'm just pretending it's not happening. He's in my disassociative box. Like, I know Tapper's going down, but I'm just moving it to the side. Right. Exactly. A judicial branch cannot tell them what to do. Well, right. And, again, we've talked about this multiple times. And I think one of the easiest ways, and I'll kind of close on this, everyone, one of the easiest ways to figure out what they're talking about, and maybe if they could, think of this too, it might help them. That when we're dealing with laws, judicial review of constitutionality is the thing. Like, the Congress doesn't make the determination that their law is constitutional, right? Of course, they write a law and they're like, well, we're writing a law, it's our job, and of course it's constitutional. That's not their job. It's the judicial branch's job to determine if the law is constitutional. You can't just cut out a branch of government and say, well, we've determined this is constitutional. No. And that's why we have a judiciary, because Congress screws stuff up all the time. Now, there are certain elements where certain powers of branches can be limited. And that's a lot of what we're talking about here. And I remind everybody here of the Alien Enemy Act in this case. So the Alien Enemy Act construed as permitting a resort to the courts only to challenge the validity and construction. So validity and construction of any statute can be challenged in court, and to raise questions of the existence of a declared war for the Alien Enemies Act and of alien enemy status. So those are a couple of elements specific to this. But the key here is that if the executive branch has already gone through and done their process, and the process under the law is set out in a specific way, that's what we're talking about. Like, courts can't come back in and be like, no, you can't do any of that. But if we've got a question of the validity of a statute, the construction of a statute, those questions are for the judiciary, and there's no exception. There's no like, well, this particular piece of paper that I wrote on is now not touchable by the Supreme Court, because that would be a violation of our checks and balances system. You can't just write a law and say and that's it and this is final. You can't do that. Like an executive order, like, well, because I said so. Like, that's not how that works. That doesn't work that way. So you gotta be like, get yourself sorted out here, and go back into the law school and think about what you're doing. If these 6 people aren't returned, who would be arrested? Good question, and their return is not requested. The 6 people in this case, we're not talking about them returning or bringing them back to the U.S. That's not what this order is. So that's not on the table. This order is stating there are 7 pieces, and they are entitled to their 7 pieces. And if these 7 pieces aren't given, then the court comes in here and says you need to report back that you have told them the 7 pieces. And then if you don't, we've got pains of penalty and perjury, and we will have a second violation of a court order. Yeah. Watch an interview between. No, I have to limit that. I don't know why I've been, everybody, I adore watching the, oh my gosh, how to describe it best. I watch a lot of Asian TV. Yeah, I said it. And particularly right now, Chinese dramas. Oh my gosh, the costumes. Anyway, as I'm working on my Mandarin, and I tell you what, since this has happened, I had to take a little break. I'm in Thailand now. I had to go to Thailand. So I'm watching the Thailand TV because I can't even handle it. So this is big. We're in trouble, everybody. Oh my gosh. Oh, they are really good. I got to get back to China, though. I mean, I love Thailand and Vietnam, but I gotta. Oh my gosh. Yeah, so they've got multiple streaming services where you can find it. Of course, the K-dramas and the J-dramas, and for a while I was hooked on Brazil. I was like, what did they just do? And then, of course, the telenovelas. Anyway, everybody has their own way of kind of, backing away from all of this, and that's what I do. So that's important. Okay, there's a determination to be a violation of court order. Who's responsible for? Well, whomever was part of the violation. So who gave the order? Who allowed it? If the attorney knew about the preliminary injunction, and then they knew that people were getting shipped, anybody that touched the situation, that had knowledge of the preliminary injunction, they could all be held responsible. And that was brought out during the JGG hearings, where he said, who knew about the order? Who was the person that called the plane? Who arranged the buses? Who set the people up? Who? All of these people involved, all of them could be held in contempt for violating the order. Oh my gosh, the Love Boat. Yes. Oh my gosh. Mystery Science Theater. Oh my gosh, I love that too. I don't know. There's something about the Portuguese in the Brazil. That language, for some reason, is fascinating. It's just absolutely fascinating. Yeah, and the only thing I find that can take my mind off of what's going on in the U.S. is if it's in a foreign language. So I need something. I need the Thai language. I need Mandarin. I've been working so hard on Mandarin, though. I think I'm burning out. I need the Korean. I just got to have it. Of course, Doctor Who, right? Love Boat, right? Dallas. Oh, my gosh. Of course. We got to do what we got to do to take care of our mental health, right? Garcia's still moving. Oh, yeah. And Garcia's a hot tamale right now or a hot potato. because, the attorneys there are in a lot of trouble. The judge on Friday was like, this is BS and I'm not going to take it anymore. So get yourself sorted out. So we're right in the middle of things starting to go really quick. So it's a hurry up and wait situation with Garcia. And with the hearing on Friday, there was another order given, like get yourself sorted out in the next couple of days, because they're waiting on some privilege log paperwork. And once that's been filed and that's been briefed and looked through, then we will have the next step in place. So that's still going. Oh, Attorney Wu. Oh, I love it. Oh, she's amazing. With the whales, oh my gosh, sometimes I listen to the whale sounds and I'm like, that is really relaxing. Octopus Files, I don't know about that. Star Trek Voyager, oh yeah, that's classic. Thank you, VC. Yes, that's a docket for Mr. Garcia. So again, we have about a dozen AEA cases going where habeas corpus is being requested by about a dozen people, saying, hey, we got notice that they're trying to move us. This particular case, this DVD case, what's so important here is this is the class action suit. This is the lawsuit where they're saying we are not citizens. Fine. We're going through the immigration system. Fine. But why are you sending us to another country that's not in the immigration papers? So immigration's like, go back to your country of origin or your citizenship country. And, they're like, this is not it. And actually, in this case, we're dealing with someone from Myanmar, oh my gosh, I'm going to say it wrong, and Vietnam as two examples. Like, what are you doing in South Sudan? So that's the problem. Who would do the arrest for contempt if they refuse? Well, I mean, anybody, really. The court can deputize anybody to do it. Anybody with a law license with an obligation to follow the Constitution, right? So you don't have to have, you just have to have the authority in order to do that. And if a court gives you the authority to go arrest somebody, and we would probably have full arrest warrants going if they didn't show up, then you've got arrest warrants. You've been told by the court to go and arrest that person. No, it doesn't have to be the DOJ, and probably won't be. The DOJ is kind of compromised. Yeah. So, I mean, they could ask me if they want. Hey, judge in Massachusetts, let me know, right? You got my bio. Let me know if you need somebody. I'll take them down. So, yes, let's go ahead and wrap up our live for tonight. Thanks for coming by, everybody. I do know that Hawk and Falcon are doing YouTube, and they may be on right now. I don't know if they're on tonight or not, but make sure to go and check them out sometime. That's a lot of fun. We've got a lot of really great creators over here trying to explain how things are working. So I'll be back again very soon. Let my voice heal up a little bit. Thank you all for coming and joining me. And as always, the moderators, oh, you're amazing. Thank you, moderators. Have a great night, everybody. And I'll see you again very soon.